Our next speaker, or third speaker, graduated with a law degree from the University of Singapore in 1979. He started his legal career in 1980 in the local firm of Murphy and Dunbar. He also joined the law faculty of the National University of Singapore in 1984. 2 years thereafter, in 1986, he obtained his Master's of Law from Cambridge University. In the same year, he obtained his diploma in trial advocacy from Harvard University. In 1995, he was appointed Judicial Commissioner of the Supreme Court of Singapore. Well, the rest is history. He is now the judge of the Supreme Court of Singapore. Let us give a big hand to our third speaker, Honorable Chu Han Tet.
Honorable Chief Justice Pangamiban, Honorable Judges, Your Excellencies, ladies and gentlemen. I believe that the organizers have very kindly produced the paper that I have written. It's somewhat murkily entitled, Treading the Forever Mill of Cosmic Time. Maybe I should begin by explaining that title. When I was asked to talk about liberty and prosperity, I thought what a wonderful subject that would be, and I wonder how many hours I might be given to talk about that, and I was mildly disappointed to be told that I have about 10 minutes. So I prepared a rumination of the broad philosophical picture of what I envisage prosperity and liberty are in relation to each other and to ourselves, particularly to myself. I've been speaking too long as a judge. Now to speak for not as a mouthpiece for anyone, but myself personally, because that's how judges are trained. Judges give opinions of their own and not as a mouthpiece for anyone else. So having given a short dissertation on what I personally think the relationship is between prosperity and liberty and ourselves, I would like this morning to just spend a little bit of time to talk on some aspects which are not covered in the paper. First of all, prosperity and liberty are themselves universal values. They are universal because everybody wants them. Everyone wants to be rich. Everyone wants to be free. But the implementation and the achievement of liberty and prosperity, where these are concerned, there are no standards. Each one in each country has to find its own focus and to find its own way and standard in balancing the moves to achieve these prosperity and liberty. But where do we begin? Where do we fix our point of focus? Before I mention it, I should say that while we use the terms prosperity and liberty together as a pair, we might overlook some equally important values such as security and education. And where do these feature in the contemplation of prosperity and liberty? They are all interconnected, they are all important, and they have influence over each other. Therefore, I think, in my own view, the focus should be on liberty, for the reason that prosperity itself is something that might take time. Equally, education may take time. And therefore, if the focus is on liberty, each country, each person is free to contemplate how much liberty needs to be curtailed so that the country and the individuals, the community can go about the business of making money to get further prosperity, and then from there to reinvest in education. The role of education, which has been touched on in some degree by previous speakers, is important because education is the means whereby knowledge, wisdom, and judgment will emanate. And from these, it helps us to identify the values that we need and the question of how much we are prepared, for example, insofar as liberty is concerned, to understand and appreciate what liberty means, how much should be given up, and for how long, and how hard would we fight for it. Now, in coming back to prosperity and liberty, the formula that I think my own country has adopted is a fairly simple one. My country has only 4 million people. It gained its independence 41 years ago. It's become reasonably prosperous. With 4 million people, we have more than 6 million cell phones. So we think that the formula really is to have a strong corruption-free government, an independent judiciary, and the respect for the rule of law. And what is more important, underlying the three requisites, is the understanding by all three organs of state, the legislature, the executive, and the judiciary, that the importance of these requisites are respected. But we have talked at some length and in various ways recognized the need for the rule of law. But it is a very strange term because the rule of law will clearly have different shades of meaning for different people and different countries. And even within a particular country, whether it's, say, a common law country, such as the one that I come from, there will be differences in opinion between legal positivists and natural law lawyers, because they may apply different standards and achieve different results, all proclaiming the adherence to the rule of law. So where do we begin? Well, I revert to the more pet value of mine, and that is education. I believe very strongly in education. I believe in understanding not just the law, the community, but insight into ourselves. And that is where I think the lesson from Sigmund Freud is important. He was probably the first person to identify the problem of the unconscious, the problem of our lack of self-knowledge. And for everything that we do towards achieving prosperity and liberty, we need to do so after critical examination of our own selves to gain a greater insight into our needs and our desires and how it will influence others and whose actions will then in turn influence ourselves. So with that, I thank you very much, and I hope the paper will not be too murky.
Thank you, Chief Justice Chu Tek, for your very interesting and thought-provoking lecture. We are glad to hear liberty and prosperity from an entirely new and philosophical perspective. We have just heard the different perspectives of our distinguished speakers. I am sure most of you are eager to interact with them, so we will now proceed with the open forum. We have placed microphones in the strategic areas of the hall. Please raise your hands and feel free to approach them if you have any question. We have also usherettes to whom you can submit your questions. Let me briefly give you a rundown of some of our speakers' important points. Chief Justice McLachlin stressed first that there exists a distinction between the rule of law and the rule by law. The former is the better rule, and it has sustained Canada from all forms of crisis. Second, the linkage between liberty and prosperity may be viewed narrowly or broadly. The narrow linkage pertains to the indispensability of rules to govern contracts and judges to enforce them. On the other hand, the broad view refers to the country's whole support system, that is, the security or stability of a country, the education of the people, and the independence of the judiciary, and so forth. Justice McLachlan also pointed that the real questions are, do we strengthen the liberty of nations? How do we increase the prospect of nations? As judges, he reminded us, and I reiterate, that whatever we do, we must do for the good of our country. Senor Promo enumerated that the key steps in ultimately achieving liberty and prosperity are, first, is the existence of a basic rule of law. Secondly, a fair and equitable development and applications of those laws in order to generate prosperity. And thirdly, international cooperation and trade to add long-term stability to the results achieved. Lastly, Chief Justice Chu Han-Tek admitted that harmonizing liberty and prosperity and assigning to each its proper value has been an intractable, age-old problem. He emphasized that the Million Declaration was made in the true spirit of liberty and prosperity and deserves to be given the fullest consideration in any study relating to the philosophy of liberty and prosperity. He emphasized that self is inconsequential. It lives not for any singular life, but for the lives that track the forever meal of cosmic time. He said that to think of others requires careful attention to the cultivation of some attendant qualities, which are honor and nobility. Now we are ready for the open forum. Any question?
Well,
Any question?
yes, Ellen. Yes, it seems that,
Chief Justice Pangilinan?
yes.
Okay.
It seems to me that the other heads of delegation are a little shy, so I will open up the open forum. But first, before I ask the question, let me give my own tribute and thanks to the three panelists. You know, it has been difficult but rewarding for us to be able to invite Chief Justice McLachlin. I've met together with our former Chief Justice Davide. We met Chief Justice McLachlin 4 years ago when we traveled to Canada to be able to sign an agreement with the Canadian International Development Agency, which gave assistance to our judicial reform program, if you remember, Madam Chief Justice. And on that occasion, you opened up your court and hosted us to lunch, and afterwards to a 3-hour give and take with your justices. I remember very well one of the questions raised, I think it was by Justice Claire Dubé. Yes. And she said, you know, the Supreme Court of the Philippines, we notice, always cites with approval decisions of the Supreme Court of the United States. And you even cite in your decisions the author of those decisions. And so we have read in your decisions in the Philippines citations of Justice Frankfurter, of Justice Holmes, but she complained, never have we seen your court cite the Canadian Supreme Court. So we were a little taken aback, and after a short shock, I replied, we apologize, Justice Dubé, for that. Really, we haven't been able to cite the Canadian Supreme Court in any of our decisions. But if I may also observe, I do not know of any Canadian Supreme Court decision citing the Philippine Supreme Court. So that, I think, opened up the rather formal atmosphere at that time. But it started, I suppose, some friendship between our two courts. And that also started the courtship to bring you over here, Your Honor. I remember having written you over 2 years ago to first invite you to come for a lecture in connection with the retirement of Chief Justice Davide. But you replied that the whole year of the 2005 was so occupied by you, and so I said, how about next year? And you said, yes, I will come next year. So since that time, I've been thinking, what should the great Chief Justice of Canada, a lady Chief Justice, do in the Philippines? So I had to think of an international, this global forum that you can address. So indeed, we are lucky and thankful that you have come, but not just for this forum. You're staying not only for 3 days, you're staying for 6 days. And in the process, be able to address not only this forum, but the Philippine Bar, and you're addressing that tomorrow, and also the Philippine business community, which you are addressing on Monday. You're also giving a televised interview. For all this, Madam Chief Justice McLachlin, we thank you.
Thank you.
Senor Fernando Pombo, I met last May because Justice Kennedy insisted that I should meet you. You see, I was in Washington in May of last year, and I was inviting Justice Kennedy to come over for this forum. And unfortunately, he had to be in San Diego. That's why I said, well, you'll be in San Diego, we'll be in Manila. That's no problem in this age of technology. So we arranged that teleconferencing, which we aired earlier this morning. But after we discussed the forum, he told me, you must invite my friend, Fernando Pombo. And so I said, well, I'm going to Madrid to meet him. And so the following day, we flew to Madrid and met Senor Fernando Pombo. And we discussed in his magnificent law firm, situated in the most modern part of Madrid. I call his building the Leaning Tower of Madrid because it is the modern version of the Leaning Tower of Pisa. It's really leaning about, is it 45 degrees? Over a busy avenue in Madrid. But anyway, I discussed with Don Fernando our purpose in having this global forum. He said, well, you know, this is rather urgent because I have many other things to do, but I will try my best to be there. And now he's here. This is his first international trip as president of the International Bar Association. Thank you, Senor Fernando Pombo. Justice Chu Han Tek, I have met in Singapore rather superficially, but I was intrigued by the title of his piece about threading the forever meal of cosmic time. I thought that I knew a little of something, a little of everything, but looking at this title, I knew nothing of this. But I had to read your paper, and I'm happy that I did. But like Chief Justice McLachlin, you did very well in discussing the rule of law, except for a different perspective, which brings me to my question. Chief Justice McLachlin, I think, has one message to all of us, if I may summarize it, and that's the rule of law. Provided we have the rule of law in place and we follow it, then most of our problems will be resolved in our pursuit of liberty and prosperity. Would that be a fair summary in one sentence of your message?
Yes, I think so.
Yes, and however, Justice Chu was saying that there are different perspectives really, and that it's not enough because there should be a calibration of how much liberty should be allowed in the pursuit of prosperity, how much restrictions and curtailment there should be. Perhaps we can have a little bit more of that from Chief Justice McLachlin. Would you say that following the rule of law is enough? We never calibrate or curtail liberty in order to pursue prosperity, or vice versa?
Is this on? Yeah. For me, it's not an either-or thing. In our Constitution, in our Charter of Rights and Freedoms, as in many other constitutions, there is a balance set up. No right is absolute. That's the wrong way to think of the rights that are guaranteed by constitutions or the UN Declaration or whatever. We live in societies, we live in groups, and we have to find ways to live together, and the individual right, perhaps to do business in a certain way, or perhaps to express himself in a certain way, or whatever it may be, often in practice will run up against the public interest. And it may be harmful to members of the public to allow a certain right to be expressed in a certain way. And this is what I mean by accommodation and compromises. My vision of the rule of law is not of absolute principles that always trump, but it's of a mechanism, a process that allows us to find the accommodation between the conflicting interests. Sometimes they will be public interest, group interest, collective interests, and individual interests. Sometimes there'll be different conflicting group interests. For example, this tribe and that tribe, or this religion and that religion. or they may be individual. But a modern, well set out constitution, which is at the basis of the conception of the rule of law, will have within it a mechanism for adjusting these rights. Now, the United States Constitution, which you're all familiar with, is very interesting because when the Founding Fathers set out the Constitution, they said, no man shall abridge free speech, for example. Absolute statements of rights. But even in the United States, the courts, as you will know, have developed doctrines whereby those rights are modulated, and the exercise of those rights is modulated in the public interest. And that's what the judges had to do there in a very creative way. So there were doctrines of, you can't shout fire in a crowded theater if there's no fire, and that kind of thing. So there are limits, for example, to free speech. When people started drafting constitutions in Europe, they realized that there had to be proportionality. There had to be ways to balance. And so they did that, and we borrowed that in Canada. So Section 1 of our charter says everybody's liberties are guaranteed, except to unless the state can demonstrate that it's reasonable and justifiable to limit them. And so then the burden shifts to the state to say freedom of speech or freedom of movement or whatever it is should be limited in this circumstance. And the courts basically are there to rule whether the government is in a certain area, although we give quite a bit of discretion to government. So when you come to economic prosperity, development, and so on, I think as well as other collective interests, I see the rule of law as compatible with them, provided you have the public interest being able to be brought in, if you wish, inside the rule of law. So it's not the rule of law against these interests, it's how within the rule of law do you find compromises and accommodations.
Well,
Yes. Chief Justice Peck.
could I just elaborate on one little point concerning the rule of law and the fact that different judges in different countries perceive this notion of rule of law differently. Part of the problem I think we have in the common law world is that judges tend to understand or to find the solution to problems by the process of the decision by analogy. The reason of a court is always focused on what went on before. Now, what went on before in terms of liberty, for example, the curtailment of personal liberty during the Second World War and the curtailment of liberty in the circumstances of today are different. How do we as judges resolve problems like that by reference to phrases such as the rule of law, unless we have some standards? And when I talk about standards, I'm hoping to find universal standards, because looking around me, I can see judges from the European countries, judges from Commonwealth countries, judges from countries with very different modes of adjudication. So my hope is that perhaps in the course of this forum, we'll see a little bit more contribution from other jurisdictions on what they understand by the term the rule of law. In my case, for example, the critical difference would depend on whether the judge in the common law country is himself a legal positivist or a natural law lawyer. I think that makes a lot of difference. Sometimes the results mask the position the judges take. And if there's time, I might talk a little bit more about it, but maybe for the time being, I will leave the point.
From my perspective, the balance between individual rights and public interest, protection of the community, is especially relevant when you are dealing with terrorism. Terrorism also as a major threat to prosperity. And many countries, including my own country, Spain, had been through the last decades looking for a balance between restriction of fundamental rights and securing the lives of the people. How to prevent terrorists from succeeding in their attacks to human beings for whatever reasons, and at the same time keep the fundamental rights of people to access to justice, to a proper defense, and everything else there still. At IBA level, we published 2 years ago a study which was the result of several professors having investigated, and several international experts, including Richard Goldstone and Mary Robinson and others, about the balance between terrorism and the law. Where are the limits? Is anything permitted to prevent terrorism from succeeding? Where do we put the limits? We certainly have seen a situation in the last years where the emblem of democracy, the United States of America, has been discussing at judicial levels, including the Supreme Court of the United States, how far the war on terrorism could go against the rights of individuals, and particularly how to limit the abuses on detention of people at extraterritorial locations such as Guantanamo, with the reason of we are trying to prevent more terrorism. Where is the balance of that detention abuse? Where is the balance of torture being applied by some governments against suspected terrorists and the rule of law still be there? I think this is one of the huge issues we have in front of us today. Fortunately, the Supreme Court of the United States recently said the detention itself in an extraterritorial location, Guantanamo, and we at the IBA discussed that in Chicago a month ago, was illegal. The method applied to the detainees there was illegal. A national situation, the lack of an applicable law to the place of Guantanamo in Cuba at the US base was an illegal approach.